What causes a product to be defective in a product's liability claim under Florida law is one of three legal theories. The first theory would be that the particular product was improperly designed by the manufacturer. And in essence, what that means is whoever your client is suing on behalf of a specific product is making allegations that the company that designed that product, that went into their back room and did testing, did analysis, did engineering, and decided how are we going to make this particular office chair or whatever it might be, that they didn't do a good job in the design process. They didn't take into account the most up-to-date scientific standards. They didn't take into account the most up-to-date government regulations or other guidelines that would tell a manufacturer exactly how they should put together and design a specific product. That's a design claim. The second of the third types of product liability claims, again under Florida law, is a manufacturing claim. And under that claim, you are presenting the argument against a manufacturer that not necessarily that they designed a bad product, but that they didn't meet their own design specifications with this particular product that may have injured or killed one of my clients. And just to use again the office chair example, let's say that a certain company has designed an office chair and there's supposed to be 3 screws in the bottom that hold that chair onto the bottom so you don't fall off and hurt yourself. If the particular chair that hurt my client, if they didn't put the screws in the chair and then my client sits down, falls off the chair and hurts themselves, we would put forth in that particular case a manufacturing defect claim that you didn't design it to your own specifications or there's some other issue in the manufacturing process. They didn't use the right materials or something like that. The third legal theory that makes a product defective under Florida law is a warnings claim. And under those types of claims, you are arguing against the manufacturer that they failed to put warnings on a specific product or that they put inadequate warnings on a specific product that weren't good enough to alert your client, my client, the consumer, that the product maybe shouldn't be used for certain purposes or that if you use it in a certain way, it could result in harm or death. And as a practical matter, when you file a products liability lawsuit in Florida, you generally allege all three of those theories at a start, and as you head towards a trial, you narrow down and decide which one or which ones might be the best ones to obtain a good result for your client at a trial.